Hello, I'm Professor Maya Steinitz, and I will spend the next few minutes talking about my most recent work on litigation finance, which is titled Incorporating Legal Claims, and is forthcoming in the Notre Dame Law Review. In incorporating legal claims, I suggest that we need to shift our paradigm of understanding litigation finance, from what I call the legal ethics paradigm, which is the current discourse, to what I call the finance paradigm. So I'll spend the next few minutes first explaining what is litigation funding, then I'll explain what is the current legal ethics paradigm, and then I will explain what I mean by a finance paradigm and what do we gain once we shift our perspective from the legal ethics paradigm to the to the finance paradigm. So when we talk about litigation funding, we talk about the financing by a non-party of a party's litigation for a profit. We have seen in recent years the emergence and the growth of an industry, a global industry of financiers who invest in other people's lawsuit, usually on a non-recourse basis. If there's a win, they get a chunk of the awards, and if there's a loss, they lose their whole investment. At first blush, this of course reminds us of the contingency fee. And because it's such an intuitive analogy, in fact, it is the implicit or explicit premise of virtually all of the litigation finance literature that litigation funding is very similar to the contingency fees. Before I say what I think about that, I will just note, by still defining litigation funding, that scholars of litigation funding tend to distinguish between consumer funding and commercial funding. Consumer funding is the funding of personal claims such as personal injuries and divorces, and commercial claims and commercial funding is the funding of large commercial claims such as business-to-business contract disputes, international commercial arbitrations, antitrust cases, and so forth. The plaintiffs in this context tend to be sophisticated players, and the sums in questions are very large. My scholarship in this particular paper relates only to commercial funding, does not speak to consumer funding at all. So with that little introduction in mind, what is the legal ethics paradigm, as I refer to it? The legal ethics paradigm, as I hinted, starts with, again, an implicit or explicit understanding that litigation funding is similar to contingency fees. And from that follow a set of common concerns about litigation funding and whether it should be permitted and under what conditions. At the heart of the concerns are questions regarding who will get to control the litigation. Would it be the financier or the plaintiff? And is it legitimate that a financier would control the litigation? Specifically, concerns relate to who will control the choice of attorney, the strategic and day-to-day management of the attorneys, and who would control settlement decisions. Closely related to the question of control is the question of conflicts of interest. It's clear that a financier may have conflicts of interests with the plaintiffs, just like a contingency attorney might have, for example, conflicts regarding when to settle and for how much. There are also other similarities, such as the problem of commodification. A plaintiff may wish to pursue injunctive relief, whereas whoever is financing her case, an attorney or a financier, may wish to monetize the entire value of the claim and receive only cash as opposed to injunctive relief. Because of the similarities between contingency fees and litigation funding, the logic of most of the discourse then goes on to basically say, well, we need to regulate the litigation funding industry in these arrangements the same way that we regulate the attorney-client relationship. And what that means is we apply the champerty framework. Champerty is the doctrine that generally prohibits the funding by a non-party of a party for a profit, or allows it only under certain strict conditions that vary state to state. And we also see the attempt to regulate or understand the regulation of litigation funding as using the legal ethics regulation basically to tighten the regulation of what attorneys can do and cannot do in a funded arrangement, so as to try to get at some of these issues of control in conflicts of interest, etc. In my view, what this legal ethics paradigm does is it both over-regulates and under-regulates litigation funding. It over-regulates it because it prohibits certain transactions, certain funding that a lot of people probably would find inoffensive. For example, certain deal structures may be champertous when what is being funded is the case of, say, a startup company who has a patent and that patent is being infringed by a large industry incumbent. Most people, I believe, would not be offended by this kind of a litigation with a sophisticated plaintiff being funded, but it could be structured in a way that is deemed champertous. So if champerties are lents, those kinds of financing may be out under the legal ethics paradigm. The legal ethics paradigm also leads to under-regulation because it doesn't treat litigation funding as a form of finance, which I argue is first and foremost what it is. So the legal ethics paradigm has nothing to say about whether funders should be capitalized, well capitalized, and what that means, or whether they should be licensed. So that in a nutshell is the legal ethics paradigm. What is the finance paradigm that I suggest? Well, I start with the insight that all of the problems that have been the focus of the litigation finance discourse, for example, who controls the litigation, how will we manage conflicts of interest, etc., are nothing other than the old familiar problem of the separation of ownership and control, which is at the heart of business law generally. In other words, I suggest that rather than seeing the funder-funded relationship as predominantly a relationship that's similar to the attorney-client relationship in the contingency fee case, we should regard the relationship as a joint venture. And we know how to deal with joint ventures. We know how to minimize. We haven't solved all of the problems of the separation of ownership and control, but we know how to minimize them. And so once we shift our understanding from litigation finance as a form of champerty to litigation finance as finance, we can start thinking about how to incorporate the solutions to the problem of the separation of ownership and control from the general business law context to litigation finance. In my paper, I spend a lot of time discussing a set of deals that can teach us part of how to do just that, how to incorporate solutions to the separation of ownership and control to co-owned litigations. The way I do it is by discussing a set of deals that, to the best of my knowledge, have not previously been discussed in the academic literature, in which parties have used corporate governance principles in order to govern litigation. This was done not in the litigation finance context, but rather in the context of, generally speaking, mergers and acquisitions. The problems that parties were trying to solve there is that the seller and the buyer couldn't agree as to how to price a very large litigation, and therefore how that should reflect on the price of the corporation. And so what they've done is they issued litigation-backed securities that were tied to the future proceeds of the litigation. And those securities were traded, in many cases on the NASDAQ, allowing the markets to price the value of the litigation and thereby making it easier to price the rest of the corporation. In some cases, this was done simply by issuing securities backed by the litigation finance proceeds, and in other cases, it was done by creating a special purpose entity that owned the litigation, so a spin-off of the litigation into a special purpose entity. And part of what I discuss is the litigation management agreements that have been set in place in those instances in order to deal with the problem of the separation of ownership and control, or the problem that there were now co-owners of the litigation and they may have conflicts and different ideas on how the litigation should be managed, and they might both want to control the litigation. So these management agreements dealt with issues, dealt ex ante in a transparent manner, and clearly stated what would happen in a case of a conflict, what principles would control, which individuals would govern the day-to-day management of the litigation, which individuals would control the attorneys, what principles would guide them in doing so. In at least one case, a litigation management agreement stated that the original owners of the claim are structuring the deal so that they can take injunctive relief as opposed to cash. So all of that has been set up out again clearly, transparently, and ex ante in these litigation management agreements that basically incorporated principles of corporate governance into litigation governance. We can also draw more from business law once we start understanding funded commercial litigations as joint ventures. We can understand that entity selection, so if we spin off a litigation or if we embody it in a business entity, which kind of business entity we select can bring in different statutory and common law regimes to govern conflicts of interests. We can incorporate principles of incentive alignment and compensation. So we can, for example, envision deals that are structured so that the litigation financier has to keep skin in the game. They can't sell off all of their litigation proceed rights. And the list goes on and on. It really opens up a wide field to explore. So after I discuss these concrete deals and how they've dealt with litigation, corporate governance turned litigation governance, as I call it, the article generalizes what we learn once we shift from having as our organizing idea in the field of litigation finance the idea that litigation finance is a form of champerty, to our organizing idea being litigation finance as a form of finance. So to sum up, I suggest this paradigmatic shift in how we conceptualize litigation funding. I suggest that we view it as a joint venture. I explore some of the implications both to how we can regulate the litigation finance as an industry once we start regarding it as a pocket of the larger financial industry, and also how we can deal with the problems that disturb a lot of the commentators, problems of who controls the litigation, how to resolve conflicts, whether or not to commodify legal claims by structuring litigation funding in ways that are similar to other joint ventures. That's it. If this interests you, please read my paper, Incorporating Legal Claims, forthcoming in the Notre Dame Law Review.